Welcome to the Anthony John Esquire podcast. I am AJ, and this episode is the follow-up that I promised at the end of my pre-election podcast. So, point one is that the election happened. Chris Taylor won over Maria Lazar in the race for a seat on the Wisconsin Supreme Court. I'll tell you where I actually came out on that. After the last podcast dropped, I eventually did decide to vote for Lazar for three reasons. First, I read through both candidates' judicial decisions, and the bullshit to brilliance ratio was roughly comparable. Lazar came out slightly ahead, though, and she had more to work with. Taylor has only been on the Court of Appeals for 3 years out of a 6-year term, so the sample was thin. Lazar has been on the bench for over a decade, roughly 7 years on the Circuit Court and 4 on the Court of Appeals. Despite having only about a year more seniority at the appellate level than Taylor, Lazar has authored nearly twice as many opinions. Make of that what you will. Either Taylor wasn't being trusted with assignments, or she was protecting her record ahead of the run. Neither interpretation, in my view, is very flattering. For context, Chris Taylor was appointed to the Dane County Circuit Court by Governor Evers in 2020. She was elected to a 6-year term there in 2021, and after having served a couple years of it, she ran for and was elected to a seat on the Court of Appeals in District 4 in 2023. She served a couple of years of that and has now in 2026 won a 10-year term on the Wisconsin Supreme Court. At this pace, with any luck, she'll run for governor in November and just appoint her own replacement. When I called one of Lazar's opinions intellectually dishonest and internally incoherent in the last podcast, I meant it. I should have been clearer, though, that as a criminal defense attorney, that's closer to Tuesday than it is to a scandal. Criminal defense attorneys lose a lot. The system is designed to convict people efficiently. The principle that the state has to prove you guilty beyond a reasonable doubt to a unanimous jury of 12 of your peers, that's true, but it really only matters at trial. The pretrial law, the law on police authority, the emaciation of the Fourth Amendment, the ever-lowering bar for charging, and the admission of evidence that the state wants in, all of that is stacked against the defendant. That's a different episode. The point is this. When I call a decision intellectually dishonest, I mean it, but it comes across as more scathing than I think it really is. And I know non-lawyers hear it as a condemnation. To lawyers, it's just an occupational assessment. If that scares you about our system, congratulations, you're paying attention. The specific decision that Taylor lambasted Lazar for, the one they argued about during the debate, is actually one that I'll cover in detail just a little later in this episode. I read the Lazar opinion, I read the District 4 opinion that it was supposedly in conflict with, and I read the Supreme Court decision about the two. My conclusion was that Lazar did the right thing, which made my overall assessment of their judicial decisions come out slightly in Lazar's favor. The second factor was judicial role. Lazar simply articulated it better. I covered this at length last time. I had suspicions about Lazar's political leanings, and still do for whatever they're worth at this point, but she was saying the right words. Taylor, at least until she got on the debate stage, had been pretty open about her political dispositions. So again, there, slight edge to Lazar. Third, on recusal, Lazar's position was clear. She hasn't been with her old firm in over a decade, and she still recuses when cases involving her former colleagues come before her. Taylor was vague, and that concerned me. Recusal has been a recurring problem in Wisconsin. It started with Chokegate, the incident where then Justice Prosser was accused of choking Justice Bradley the Greater, the term we liberals use for Ann Walsh Bradley to distinguish her from Rebecca Dallett Bradley, or Bradley the Lesser, though it's going to be irrelevant when she's replaced by Justice-elect Taylor. Anyway, Justice Prosser was accused of choking Justice Bradley during a chambers argument over Act 10, and all of that went unresolved because all of the justices were witnesses and there is no quorum to adjudicate it. More recently, the liberal justices have signaled that the doctrine of necessity trumps recusal requirements. And that strikes me as dangerous, especially when there are better solutions. So the third factor also went slightly to Lazar. There were other factors. My views on abortion are entirely contrary to Lazar's, and I don't take that lightly. I'm pretty much an abortion rights absolutist, informed by respect for the law as it existed before Dobbs, and by the women in my life, and frankly, by the fact that women are half of all humans. That's not nothing. But here's where I alienate everyone equally. I'm also a gun rights absolutist. I know, put away the pitchforks. But abortion and gun rights were both constitutional rights that one side or the other hated and tried to litigate into non existence. Both rested on complicated readings of Supreme Court precedent, Roe and Heller, respectively. Democrats are for abortion rights and against guns. Republicans are against abortion rights and for guns. I'm for both. And that doesn't make me a libertarian. Privatizing the fire department is not my idea of governance. It makes me someone who thinks that legal consistency matters more than political alignment, which is also why I can vote for a state Supreme Court justice who disagrees with me on abortion and a president who disagrees with me on guns. The roles weigh differently than the issues do. All of which is to say, I ran the analysis. It was uncomfortably close. I held my nose, and I voted for Lazar. She lost, and it wasn't close at all. That's fine. Again, I'm a criminal defense attorney and a liberal in Wisconsin. I'm used to losing. I fought, I lost, I had a drink, I took a shower, because that's how it is in the NBA. You know what I do when I win? 2 drinks. Shout out to my West Wing peeps. Of the judicial races I voted in, the only candidate I voted for who won was Rachel Graham. Odd, because Graham also endorsed Chris Taylor. So I'm confident that my ballot will surface as evidence of fraud in some upcoming challenge because my votes don't make sense without an annotation. Which is a perfect segue to this episode's main subject, Wisconsin Voter Alliance versus Secord. Before I get into the merits of the case being argued before the Wisconsin Supreme Court tomorrow, some background on who Wisconsin Voter Alliance is, because their track record matters. You may know Judge James Boasberg from the news lately. He's the D.C. federal district judge who's been blocking the Trump administration's deportation flights and issuing rulings that have put him in direct confrontation with the Department of Justice. He's everywhere right now. He also has a 2020 cameo that's relevant to this episode. Wisconsin Voter Alliance, a conservative election integrity nonprofit led by Ron Hewer, was a plaintiff in Wisconsin Voters Alliance versus Pence, the federal lawsuit that tried to block Congress from certifying the electoral votes. Judge Boasberg dismissed it. In his post-dismissal order, he cataloged the suit's failures at length and concluded that the WVA had filed, in his words, a sweeping complaint filed with baseless fraud allegations and tenuous legal claims to undermine a legitimate presidential election. He then referred the plaintiff's counsel, a Minnesota attorney named Erick Kaardal, to the Committee on Grievances for potential discipline. And that's the attorney arguing before the Wisconsin Supreme Court tomorrow. WVA was founded partly in response to the so-called Zuckerbucks controversy. Mark Zuckerberg's Center for Tech and Civic Life sent $350 million to local election offices in 2020 to help administer the pandemic-era election. WVA and others characterized this as corrupting the process. Wisconsin voters amended their constitution in 2024 to ban that sort of thing. Critics say that the entire Zuckerbucks narrative was manufactured outrage over a legal, mundane practice, but the constitutional amendment happened anyway. Hewer, the WVA's president, was also hired as an investigator in the Gableman probe, the $250 million taxpayer-funded Republican legislative review of the 2020 election led by former Supreme Court Justice Michael Gableman. That investigation found no evidence of widespread fraud. Gableman is now facing a 3-year suspension of his law license for unprofessional conduct. Common Cause Wisconsin's executive director, Jay Heck, summed up the liberal position on WVA. A cynical, callous attempt to sow division and undermine citizen confidence in our elections by raising a non-existent issue to fuel conspiracy theories and election denialism. And the through line critics draw is that WVA has never demonstrated fraud in any of its years of litigation. But each failed lawsuit generates new public doubt about election integrity, which might be their actual goal. Here's where I break from that framing. I think that election fraud claims in 2020 were bullshit. I think that claims of systemic fraud generally are bullshit. But the WVA's underlying concern in the Secord litigation, that there might be an administrative gap between what county courts report and what the Wisconsin Elections Commission actually records, is not inherently crazy. As a matter of fact, it's actually true. And the more we try to prevent people from showing us where fraud is by refusing to look, by refusing to even let them look, that starts to seem a lot like we're trying to hide something. So here's the thing. It's not even conjecture anymore. In 2023, Scott McDonnell, the elected Democratic Dane County clerk, conducted an independent review of roughly 1,000 names from the state's adjudicated incompetent list. He found 95 people in Dane County alone who had voted after a court stripped them of that right, casting more than 300 ballots across multiple elections going back to 2008. And to be clear, those individual votes may well be fraud. Each one of those votes was likely cast by someone legally ineligible to cast it. The question isn't whether it happened, it did. The question is why. And the most likely explanation is administrative rather than conspiratorial. In 59 of those cases, the voter had moved and re-registered at a new address, and the new registration just didn't match the old incompetency flag in WEC's system. Address drift in a decentralized, under-resourced reporting pipeline. That's not a coordinated scheme, just a broken process that nobody fixed. Now, I want to be careful with the math here because I am admittedly math phobic, but I'm a lawyer and I also don't get to be sloppy. Those 300 votes were spread across 15 years and multiple election cycles. Presidential years, midterms, spring primaries. McDonnell didn't break them down by race or by year, so I can't tell you how many landed in any single contest. What I can tell you is that 95 people in one county, extrapolated across 72 counties, gets you north of 6,800 ineligible votes cast statewide over that period. And for context, David Prosser beat Joanne Kloppenberg by 7,006 votes in April of 2011, a low turnout spring election where roughly 1.5 million total votes were cast. I am not saying those votes swung that race. I'm saying that the scale of the problem is in the right neighborhood to matter. And that's one category. There are likewise other categories of people excluded from voting, felons, for instance. But before I ran my mouth about felons, I thought it'd be nice to actually look it up, and it turns out that to Wisconsin's credit, the felony screening system is meaningfully better. The Department of Corrections sends the Wisconsin Election Commission a daily file of people on felony supervision, and WisVote flags them automatically, and clerks get notified in real time. It's not perfect. A 2020 audit found about 8% of flagged voters weren't acted on before Election Day, and Milwaukee's ward-specific lists create their own gaps, but it's an actual system. Between 2012 and 2022, 109 people were charged with illegally voting while on felony probation statewide. In 2020 specifically, fewer than 0.003% of ballots cast came from ineligible felons. So the felony pipeline, while imperfect, is automated and monitored. The incompetency pipeline is neither. Nobody built that system. They just assumed it would work. So the legal question in the case that's being argued before the Wisconsin Supreme Court tomorrow is narrow, but it's genuinely interesting. When a Wisconsin court finds an individual incompetent to vote, the clerk of court fills out a notice of voting eligibility form, an NVE form, with the person's name, address, and findings, and sends it to the Wisconsin Elections Commission. The WEC is supposed to update the voter rolls accordingly. The Wisconsin Voter Alliance claims that there are discrepancies, that the number of incompetency determinations reported by the counties doesn't match the number of voters flagged as ineligible in the WEC's database. If that's accurate, it means some people who have been judicially stripped of their right to vote are still on the rolls. And WVA says it needs the NVE forms to prove it. The forms, however, come out of guardianship proceedings. Those proceedings are confidential under Wisconsin Statute 54.75, which seals records pertinent to a finding of incompetency. Disability rights groups and Law Forward, the progressive election law firm representing the defense, argued that releasing the names and addresses of people under guardianship would expose some of Wisconsin's most vulnerable residents to exploitation and scams and voter intimidation. Law Forward put it directly. This lawsuit isn't about election integrity. It's an effort to invade the privacy of some of Wisconsin's most vulnerable residents. WVA sued 13 counties in Wisconsin simultaneously. The legal fight has now been bouncing between the courts for years. District 4 of the Wisconsin Court of Appeals was the first to issue an opinion in these cases, so it became binding under Wisconsin's rules that Court of Appeals districts can't overrule each other and are bound by each other's precedent. All court records pertinent to the finding of incompetency are closed, but subject to access as provided in WISStat 51.30 or 55.22, or under an order of the court under this chapter. The fact that an individual has been found competent and the name of and contact information for the guardian is accessible to any person who demonstrates to the custodian of records a need for that information. In a nutshell, District 4 said that the info WVA wanted was pertinent to the determination of incompetency and that the records, including the NVE that they were asking for, was off limits to them. The open records argument doesn't suffice because it excludes stuff that's statutorily excluded, which this is. District 4 therefore explicitly refused to reach the question of whether the WVA had shown a need for the information, because what they would be entitled to if they had shown a need was not the NVE, but a couple of pieces of information on the NVE, the name of the incompetent and the incompetent's guardian. So, WVA loses because the records are closed and it asked for the wrong thing. Then we move on to the Lazar decision in Wisconsin Voter Alliance versus Secord. District 2 split there. Lazar wrote the majority, joined by Judge Grogan, and Judge Neubauer dissented. Lazar, in this case, said that it was developed in ways that the District 4 case was not. And so even aside from the pertaining to language, where she acknowledged that they were bound by a finding they didn't agree with, found that the public records law, which District 4 had not really addressed because they thought it was foreclosed by their reading of the statute, Lazar had said that WVA had shown a need. And that need wasn't just for the names of the incompetents and their guardians, it was for information in the closed file. This, too, is law in action. Lazar read the same sentence more broadly than District 4 did. Ultimately, even if you think Lazar was wrong on what pertinent means and fudged what District 4 had to say about open records, District 4 explicitly stopped short of considering need, and Lazar hung her hat on WVA having shown a need. She said, if maintaining accurate voter lists, as statutorily required by the legislature, is not a sufficient need, we are hard-pressed to articulate another. Neubauer's dissent argued that Reynolds was directly on point in controlling and that Lazar's attempt to distinguish it was faulty. That's the disagreement that sent the case to Madison. For what it's worth, I read both opinions and I think Lazar did the right thing. She engaged with the District 4 case seriously, identified what she believed was undeveloped in that court's analysis, and came down differently. That's what appellate judges are supposed to do when they believe a prior decision doesn't actually control the case before them. The alternative, merely following precedent you think is wrong just because it's precedent, isn't intellectually honest. It's an abdication. The Supreme Court disagreed with me on this, but I'm right. The Wisconsin Supreme Court reversed Lazar 5-2. The court didn't reach the merits. It bench-slapped Lazar on procedure. Under Wisconsin case law, a case named Cook versus Cook, the Court of Appeals is bound by a prior published opinion from a sister court unless the Supreme Court overrules it. District 2 was bound by District 4. Rather than distinguishing it, Lazar should have either followed it or certified the conflict to the Supreme Court for resolution. By issuing an independent holding that contradicted District 4, District 2 had exceeded its authority. The case was remanded with instructions to follow what District 4 had said. Now, as I noted, even if Lazar had fudged on whether District 4 addressed public records, they certainly didn't address need, and again, that's what Lazar hung her hat on. The Wisconsin Supreme Court opinion pretends that a court saying it doesn't have to address an issue is the same as ruling that an issue can't be addressed, and that's simply not how this works. I would also be remiss if I didn't note that the Wisconsin Supreme Court is famous for not deciding issues when the Court of Appeals certifies them. In the case where I ended up getting a statute declared unconstitutional, the Court of Appeals had certified it 3 times without the Supreme Court engaging it. By the time my case rolled around, an intrepid judge, Rachel Graham, said that given the history, the U.S. Supreme Court had decided what the Wisconsin Supreme Court had avoided. It was arguably a stretch, but it's a stretch I urged emphatically, and it got the issue resolved. When the state appealed it, the decision by the Supreme Court of Wisconsin was unanimous that the Court of Appeals had done it right in that case. But back to this case. On remand, District 2 issued a per curiam opinion following District 4 and ruling against the WVA, as instructed. Lazar wrote separately in a concurrence to put her disagreement with District 4 on the record. Make of that what you will. I think it was the right call. A judge who follows an order while writing separately to explain exactly why she thinks it's wrong is doing just what the system asks of her. So now the case is back before the Wisconsin Supreme Court for oral arguments tomorrow, April 21st, 2026. This time, the procedural issue is resolved. The court will have to reach the merits. Maybe. The question is whether NVE forms are public records, whether Statute 54.75 closes them, and whether Lazar's distinction between pertinent to and consequent upon an incompetency finding is legally sound. I should be honest about my expectations here. Kaardal, who, again, is the same attorney Judge Boasberg excoriated in 2020 and referred to a grievance committee, is arguing before a 4-3 liberal Supreme Court that already vacated his last win on procedural grounds. The tea leaves are not favorable. But here's what I want to say about the underlying issue, and this is probably where I part ways with most of my political tribe. Wisconsin Voter Alliance's concern is a real one. If courts are stripping people of the right to vote and the Elections Commission isn't updating the rolls, that's an administrative failure that matters. It doesn't mean it's systemic fraud. It probably means administrative lag. I think that election fraud claims in 2020 were bullshit, and I think WVA's litigation history reflects that. I also think you can't claim to be protecting democracy while simultaneously making it impossible for anyone to check your math. Both things can be true. WVA has a legitimate question. But given the state of our Supreme Court, they're probably going to lose. Again. I won't be back with analysis of the arguments, which by the time you hear this will have already happened. But you can watch them on Wisconsin Eye if you're so inclined, and I'll make a point to follow up if and when the Supreme Court of Wisconsin issues a decision. Thanks for joining us. This has been the Anthony John Esquire podcast, and I'm AJ. We'll see you next time.